everyone, welcome to the Real Estate Tax Tips channel. My name is Cherry Chan. I'm a chartered professional accountant located in Oakville, Ontario, Canada. And I'm on a mission to become the Google map for hardworking Canadians seeking financial freedom. Today, I have a very special guest here with me, Dan Chitiz, a litigation lawyer from CPLLP.
That's right.
Oh my God, litigation lawyer. I've never interviewed a litigation lawyer ever, so this is a first. Welcome,
It's
Dan.
a pleasure for me.
Yeah, can you introduce yourself?
Yes. So my name is Dan Chitiz. I am a litigation lawyer, as Cherry says. I work with a firm called CPLLP. I'm one of the partners there. CPLLP is a business law firm and litigation law firm. Me and my team are on the litigation side of the firm as a business firm.
Yep.
What we do is we take companies public, we help do their regulatory work, and we are involved in mergers and acquisitions work, the buying and selling of businesses. Those are my wonderful corporate partners and their team. On the litigation side, we do a wide range of litigation that's business related, and that would include real estate litigation, shareholder disputes, a lot of sophisticated breach of contract work. We do a lot of estate litigation, so a wide range of litigation within that world.
As soon as you mentioned litigation in our conversation, I was like, oh, there must be a lot of juicy court case there that we can talk about, right?
Cherry, I know about your expertise in the area of real estate and the work you do in that field. There has been a lot of real estate litigation with the rise of interest rates over the last few years. We do a lot of that work, and there are a number of very interesting stories which I'm delighted to share with your audience.
Awesome, awesome. Tell us a little bit about it. At the beginning, before our start of our show, we talked about, we essentially talked about people breaching they're backing out of the deals because they can't find the money to close the property, particularly in the pre-construction market. So tell us a little bit about your experience, what you've seen in the market so far.
So we act for a number of developers as well as for folks who are buying in the pre-construction stage. And of course, people go into a deal with a certain expectation. This is the amount I'm going to pay to buy my unit. This is what the interest rate's going to be. This is how the world is going to unfold. And then, of course, the world unfolds sometimes in a way that none of us plan for. And with the increase of interest rates, what we've seen are a number of folks coming to occupancy dates, and they don't really want to take occupancy because now they can't get mortgages on terms that they otherwise thought they might be able to. And so they're looking for ways to get out of their deals, and developers at the same time are looking to compel these folks to go ahead and complete their transactions because they entered into a contract, and the developers want to enforce those contracts. And so we arrive at a dynamic where it's really important for people to understand the developers they're dealing with, if they're buying from developers, and the opportunities that might exist to have conversations, to have a dialogue which works in everybody's interest. One of the critical things to think about is if you try and have a dialogue which leads to a mutually beneficial solution in the circumstances, because the world has changed. If you can't arrive at a situation where you can reach such a deal, then you have to think carefully about what your rights and obligations are. And it's critically important to have somebody, such as myself or a member of my team, take a hard look at the documents which represent the basis for the agreement that's there between the developer and the purchaser to determine what exactly are those rights. People make assumptions all of the time about what those rights are. They arrive at a situation and somebody takes a hard look at the document and goes, no, it isn't quite what you thought it was going to be. It's quite a bit different. And that's a valuable thing to keep in mind. Good idea always to make sure you understand it with the benefit of the insight of I would say a litigation lawyer, if you haven't been able to negotiate a deal that works for you. And that's both from the developer's perspective as well as from the purchaser's perspective.
So fantastic. So people who are trying to get out of a deal and they aren't able to do it, you may want to check in essentially with Dan and his team to at least take a look at the agreement and see maybe there is a way out. Don't make just regular assumption that, hey, like I can't get out and then therefore I cannot get out and I have to suck it up. It's not necessarily the case. Now then I have a follow-up question to that. You mentioned that you represent both the developers as well as the buyers. And I mean, throughout my career, honing in on real estate, working with real estate investors, there are developers that are backing out and they collected the money from the investor or buyers, and essentially they decided not to build.
Yes.
Yeah, so then what happened?
So in those particular circumstances where the developer has reached the conclusion that they are unable to go ahead with the completion of a project. The expenses are such that it simply can't be justified, or interest rates are such that it can't be justified. In those circumstances, as a potential purchaser, somebody who's advanced deposits, you're going to want your deposit back because the vendor hasn't been able to complete the transaction. And that raises critical questions about your ability to get those deposits back in the circumstances. So again, looking at the language of the agreement, also looking at what insurance there may be in place and government guarantees to allow you to get your money back. And that's a critical thing to appreciate as you're advancing money.
I guess my follow-up question to that is, like, there were people who put the deposit down and there were then the developers, because of rising costs of construction, were not able to build within like the reasonable cost structure.
Yes.
And they decided not to continue to build. And during that period of time, that also, I guess they're right, at least under the purchaser's eyes, the value of those units have gone up. So I guess they would never be able to recover from a legal perspective the potential appreciation of the property, right?
So if the language is such, and it often is, to be candid, where the developer on its own assessment can make the decision to not proceed with a particular project, you're absolutely right. In those circumstances, the potential investor thinks, well, why can't the developer do it? This is the kind of market where it's headed in the right direction. Interest rates now look like they're headed back down. We're moving in a direction that should allow for the investment to go up in value. But if the agreement allows the developer to say, we're not going ahead with the project, it in all likelihood limits the investor in terms of their rights against the developer. One of the really important things for investors, developers to keep in mind is the evolution of the law with respect to good faith, and parties having to deal with each other in good faith in terms of their contractual performance. If a developer is acting in bad faith, that may give an investor the opportunity to pursue the developer. And then they'll have to make an assessment. Is this a developer that I can pursue? Is there something I'm going to be able to recover there? And the other thing that's important, besides the good faith element in the law in this regard, is the idea of what the Supreme Court of Canada in a case called Satva said is, we don't just look at the language of the agreement, we look at the surrounding circumstances to understand what the intention of the parties was. At the time that the investor made a decision to invest, what representations were made to that investor? Facts. But what the Supreme Court has essentially said is, you can't necessarily just get tied to the language of the agreement. You need to look at the surrounding circumstances to understand the intention of the party. So if I'm an investor, I said, hold it a second. This looks like the investment's headed in the right direction. I don't understand why the developer, the builder really, at this point in time isn't doing what they need to do. They should get advice
Yeah.
with respect to their rights.
Yeah.
And usually they'll have a good sense of, this just doesn't seem right.
Yeah.
There's something wrong here with what has otherwise transpired.
Yeah. Well, in the Income Tax Act, we call it, I guess, prior court cases. I'm not a tax lawyer, but I've read a few court cases in the past.
Yes.
They're all related to tax. They call it substance over form. So actual what's happening over what's being in the agreement makes a difference as well. So totally understand what you're talking about. Now, but before, like, it seems like the agreement is the very important part of what we do here in
Yes.
real estate investing. I thought that would be, since you are a litigation lawyer and you always handle these shareholder litigation, joint venture agreement, at least your partners does.
Yes.
And in the meantime, my clients, a lot of them, when you ask them, hey, do you have a joint venture agreement? Nothing. Do you have a shareholder agreement signed with your partner? Nothing. So yeah, tell us a little bit about your experience and why it is so important to have these documentation.
So it comes back to the point I was making about rights and obligations. To the extent you don't have an agreement, the first question that a lawyer would be asking you if you feel you've been done down in some way is, well, what are your rights and what are your obligations? And to the extent all you have is an oral appreciation of what happened, oh, we discussed this and that, and this is the agreement we reached. Now that may be enforceable. The problem is, you can imagine the other side is going to have a different recollection as to precisely what was agreed to. And all of a sudden, what you believe your rights are is not what the other side is saying your rights are. Much better to make sure that you have an agreement, a written agreement, which is clear as to, among other things, the rights and obligations you otherwise have. So you go into a joint venture with a certain expectation. Two or more parties enter into agreement that's called a joint venture agreement. That term in and of itself isn't all that meaningful. You need to look at the language of the contract. But it may be that you find yourself 3 or 4 or 5 years down the road, interest rates have gone up, and now the person who entered into the deal saying, well, I'm going to supply the capital while somebody else is going to look after the project, buying houses, doing whatever they're doing, we're going to renovate houses, whatever the case may be. All of a sudden, the person who's advanced the money finds their life has changed and they want to extricate themselves from the situation. And now they need to come to us because often the language of the agreement doesn't address as well as it should the change of circumstances. It sets out what the rights are and what the remedies are and what the potential breaches are, but if the agreement isn't clear enough on its face in spelling out who has what rights, who has what obligations, then all of a sudden you're into a situation about the surrounding circumstances, what was the intention of the parties, and can an investor withdraw their capital? That may be something the investor wants to know. And on the other side, can the other joint venturer who received the benefit of the capital for investment purposes, can they say, well, the agreement is clear, you're not entitled to take your money out right now, you have to wait for another time. So understanding where you stand at a particular point in time where somebody wants to get their money out of the transaction is really important.
Now, so earlier on, you mentioned that it's worthwhile to protect yourself and have the agreement drafted up carefully, laying out all the rights. And one preventative measure is to have an arbitration clause. What is that arbitration clause means?
Yes, so an arbitration provision in an agreement specifies that if there is a dispute among the parties to the agreement, they won't go to court. They will have their dispute resolved by an arbitrator. There are many different types of arbitration clauses, but arbitration only applies where the parties have agreed that their dispute will be determined by way of arbitration.
And this arbitration provision can go into the joint venture agreement, it can go into shareholder agreement.
that's exactly when it should go in. You can, after the dispute has arisen, you can see if the parties, both parties or more than two parties will agree to arbitrate the dispute, but it's unlikely to happen because somebody will want to delay. When you go into the deal, everybody expects they're going to comply with their rights and their obligations. They're going to do what they have to do. If you insert an arbitration provision, the dispute will necessarily have to be resolved by way of arbitration unless the parties agree otherwise. And an arbitrator has the same power as a judge, if it's in Ontario, as a judge of the Superior Court of Justice. People often confuse mediation with arbitration. Mediation is a situation where the mediator doesn't have the ability to bind the parties to a resolution, but attempts to help the parties settle their dispute by explaining to them, how much litigation costs, and they're, trying to highlight for them why a deal is better than going to court or otherwise. But to the extent a deal can't be reached, you want somebody who has the authority to impose a decision on the parties and has the authority or same power as a judge. And that's what an arbitrator will do. And one of the benefits, the great benefits of arbitration, and I'm a great fan of arbitration, is that the parties will agree to appoint an arbitrator who has the requisite expertise. For example, if there's a real estate dispute, there's a dispute between an investor and a builder, or two parties to a joint venture agreement, you want somebody who has the commercial background, whether it's a retired judge, whether it is somebody who has practiced in that area as either a corporate lawyer or a commercial litigator, but has the experience. You wouldn't want somebody who's a personal injury lawyer in those circumstances to try and help you resolve that dispute. So you can pick the arbitrator, and the one arbitrator, and usually it's one arbitrator. In rare circumstances, the parties have agreed that if it crosses a certain dollar threshold, the dispute will be heard by three arbitrators. But generally, it's one arbitrator, and you have to pay the arbitrator. That's the one thing. The parties split the cost of the arbitrator. Ultimately, the arbitrator can make a cost award, just like a judge would have. So that's the one downside. You don't pay a judge, but you have to pay an arbitrator. But because you have one person overseeing the process, things which can be dealt with by way of a phone call. You can have a phone call with the other side, the lawyer on the other side, and the arbitrator, where you'd have to file material before the court, wait 3 months, 6 months, 9 months to have a matter heard, can be dealt with in a week by an arbitrator by way of a phone call. These are the kinds of efficiencies that, even though you're paying the arbitrator up front, it actually ends up costing you less. Not necessarily, but it has the potential to. So I'm a great proponent of arbitration, and as you said it, Cherry, the best idea is put your arbitration provision in the agreement when everybody's getting along.
Yes, absolutely. So everyone, if you have a shareholder agreement or if you have a joint venture agreement, make sure you go home and now check your agreement and see if there's the arbitration clause in there. Now, we also touched a little bit upon, earlier on, we touched upon the private mortgages. And in your world, are you dealing with any private mortgages litigation at this point?
There is a world out there of separate lenders, separate from the Schedule A banks, and the banks more generally, advancing funds by way of mortgages. First mortgages, second mortgage, whatever the case may be. Often folks who can't, for whatever reason, in their businesses or personally, cannot get mortgages from a bank. So they go ahead and they get these private mortgages. The point that I was making earlier, you better know the developer you're dealing with or the builder you're dealing with. You better know the mortgagee that you're dealing with.
The due diligence part.
The due diligence part. And it's not just about the advance of the money. It's about what happens when the mortgage comes due. I have found myself in situations acting for people who are trying to redeem the mortgage, which means the mortgage has come due, you want to pay off the mortgage, and they get what's called a payout statement from the mortgagee that they look at and they go, well, these costs just don't make any sense. They're in breach of the Mortgages Act. This isn't the amount I owe to redeem the mortgage. And they say to the mortgagee, it doesn't make sense, and they try to explain to the mortgagee, well, we need clarification. You got to change this number, remove that number. These fees can't be charged, whatever the case may be. And the mortgagee says, unless you pay this amount, I'm going to sell under power of sale.
Mm.
And
this is a great great angle. So the borrower,
yes,
when they try to discharge the mortgage, they are having a hard time because there are all these hidden fees that were not communicated or well understood that the lenders were charging.
Right.
Wow.
Or they see numbers which don't seem to be justified in any way.
Yeah, I've seen those.
And this is what happens, and I've seen it in a number of situations. And then what could possibly happen is you find yourself in a situation where there's the sale of the property and you can sue the mortgagee, but property's being sold. And so where are you?
Yeah.
You're now tied up in court, fighting with a mortgagee in circumstances where that ought never to have happened. Be extraordinarily careful going in when you're getting those mortgages, and often people are in difficult circumstances, so they find themselves needing to get that money, that second mortgage, to be able to complete a purchase or refinance, whatever the case may be. So it's difficult, and I understand it's difficult, but you do need to be careful so you don't end up in a situation where a mortgagee is the kind of mortgagee that's really putting the squeeze on you and trying to get money from you that they shouldn't, if I can put it that simply.
Yeah. So I mean, I do have a personal client's example. I think this lady was unaware of even all the costs associated at closing, because a lot of people don't understand that trust ledger thing that you sign off. It looks like numbers on one of the documents that you sign off at closing when you refinance the properties. And when I did the calculation and I look at the numbers, and she was trying to refinance, put a second mortgage, like you mentioned,
yes,
second mortgage on the property, just so that to bridge it to the point that she would be able to get another bank come in and then refinance the whole thing. And I think that bridge sort of second mortgage refinancing cost her a lot of money. And because she works with may not be even private lenders, sometimes it's tier 2 bank.
Yes.
They also charge a lot. And then when you work with a mortgage broker,
yes,
you have a mortgage broker fee on top of that private lender. And sometimes on renewal, the mortgage broker charge another fee, and then your lender also charge another renewal fee, even though they really push paper along. And they would charge like 2%. And 2% is a lot, to be honest, right? So this lady had no idea. And she's racking up probably close to 6-figure of like lender fees in one deal. And it's really sad.
Right. That somebody should come talk to me.
Yeah, but she's no longer my client now. So, I mean, it's hard to break it down to her, like, this is how much you're paying for in year 1. And then year 2, then when you do it, like when we did the calculation again and it was something ridiculous again, it just add up. It's ridiculous who she was working with in terms of getting the mortgage.
Yes.
Yeah.
You make such an important point about understanding the hidden fees.
Yeah.
And by the time they come to you and they show you the numbers, and it's like, well, what about this fee and what about that fee? And you've agreed to this and you've agreed to that. And it's really a shame when you see somebody paying considerably more than makes economic sense, than makes financial sense.
Yeah, absolutely. Well, thank you so much, Dan. You've provided so many insights. Can you let our audience know how they can reach out to you if in the unfortunate event that they do need you?
Sure.
Not that I know you want business, but at the same time, it's an unfortunate event that they need to reach out to you.
I'm kind of like the dentist. I'm a necessary evil. Nobody really wants to come to me, but if you do, if you have any questions, please feel free to reach out to my office. You can contact my assistant Kathy, whom you can reach at 416-644-9978, or at her email address, ksokolowski, OLOWSKI at cplop.com. Kathy will put you in touch with one of the lawyers who's on my team at such point as it makes sense for you to speak to somebody to assist you with your problem. Thanks very much.